Hello everyone and welcome to this video tutorial on theft. The offence of theft is a statutory offence which is set out in section 1.1 of the Theft Act 1968, which provides that a person is guilty of theft if they dishonestly appropriate property belonging to another with the intention to permanently deprive the other of it. Sections 2 to 6 of the Theft Act provide definitions of each of the elements of theft. Section 7 sets out the maximum penalty of theft, which is 7 years. Theft is a triable either way offence, and as I've said, it's contained in the Theft Act 1968. Prior to this, theft was covered by common law on larceny and was very complex. The idea behind this act was it was supposed to simplify the law, but arguably it hasn't really achieved that. Theft is still a very complicated offence. Let's start by looking at a definition of theft from section 1.1 of the Theft Act, which states, quote, "A person is guilty of theft if he dishonestly appropriates property belonging to another with the intention to permanently deprive the other of it." As always, as lawyers, we need to break this definition down into the actus reus and the mens rea. And this definition is quite technical, there's quite a lot to it. So on this next slide, I've broken down the actus reus and the mens rea elements. So from that definition from section 1, the actus reus elements are that our defendant must appropriate property belonging to another. And the mens rea elements that our defendant must have in order to be guilty are that he must have acted dishonestly and with the intention to permanently deprive. And you can see here that there's some section numbers mentioned, and that's because the Theft Act gives some definitions of these terms in the Act itself, but we also have to look at cases which help to illustrate the point. So there are 5 elements in proving theft. And we're going to look at each one in turn, starting off with our actus reus. So if we just take the actus reus on its own then, we need to understand what appropriation, property and belonging to another mean. So let's start with appropriation. Our common understanding of the word appropriation is probably just takes. To appropriate means to take. But section 3 of the Theft Act shows that appropriation is actually much more than just taking something. So section 3.1 of the Theft Act says that appropriation is assuming any rights of the owner. So you appropriate something if you do something that only the owner of that item has the right to do. And if we have a look at some cases, that will help to explain that. In the case of Pittam and Hiel, it was held that selling property is an appropriation. So if Jared decides to sell Sebi's Xbox on eBay, he would be guilty of appropriating that Xbox because only the owner has the right to sell their own property. So selling an item can be an appropriation for theft. In the case of Morris, it was held that switching labels on items in a shop so that you can pay a lower price is an appropriation for theft, because only the shopkeeper or the owner of the items has the right to determine what labels go on it. So switching the labels can be an appropriation. In Corcoran and Anderton, we saw that tugging a handbag can be an appropriation, even if the victim doesn't let go. So in this case, the defendant was trying to take a bag but didn't manage to get away with it. But the fact that he had tugged on the bag, even though he eventually let go, there was still an appropriation there because only the owner of the bag has the right to be pulling the handles on the bag. So you can start to see here that appropriation is much more, it is much wider than just taking something. If we continue on to a couple more cases on appropriation, we've got Lawrence and Hinks to look at here. In the case of Lawrence, the facts were that there was an Italian student who didn't speak much English in the back of a taxi. And when he was told how much the taxi would cost, not really understanding the currency, he offered his wallet out to the taxi driver. And the taxi driver took much more money, than he was actually owed. And the taxi driver was being prosecuted for theft for taking too much money. But his argument was, well, I've not appropriated it. He gave it to me. He gave me consent to take it. But the Court of Appeal and the House of Lords both agreed that you can still appropriate property even if you have consent of the owner. In the case of Hinks, by a 3-2 majority verdict, the House of Lords decided that even accepting a valid gift could be an appropriation. And in this particular case, our defendant was accepting huge sums of money from a cash point from a man with a very low IQ. So even though that man was giving the money to them, that was still held to be an appropriation. Our next actus reus element is property. We have to show that property was appropriated. This is defined under Section 4 as money, personal property, land and buildings, and things in action. Firstly, on this issue, we've got Kelly and Lindsay, which was a strange case. Kelly was an artist who asked his friend Lindsay, who was a technician at the Royal College of Surgeons, to remove various body parts over a number of months in order for him to draw them. And these included 3 human heads, 6 arms, 10 legs, part of a brain, and 3 torsos. And they were then being prosecuted for theft of these body parts. And the court held that a dead body is not normally property, but in this case, these body parts were property because they had acquired some value by being dissected and preserved by the Royal College of Surgeons. Then got the case of Oxford and Moss, which tells us that information on an exam paper is not property for the purposes of theft, so you cannot steal confidential information, but you can steal the paper that it's written on. 4 of the Theft Act also lists some things which cannot be stolen. So under Section 4.3, a person who picks wild mushrooms, flowers, or foliage growing wild on any land won't be liable for theft unless they're going on to resell them for commercial reward. Section 4.4 tells us that wild creatures cannot be stolen. But I should point out that this is only wild creatures. It is possible to steal a pet, someone's domestic pet. So we've looked at appropriation, we've looked at property, we need to look at the last actus reus element for theft, which is belonging to another. And this is defined under Section 5. And you might be thinking, well, surely it's obvious if something belongs to another. But actually, it's got a very wide definition under the Theft Act. And belonging to another includes anyone who has possession or control of the item, as well as someone who has proprietary right, i.e. someone who owns it. Case on this point is our interna, which surprises a lot of students because here our defendant was guilty of stealing his own car. So here the defendant took his car into a service station for repairs. When he went to pick it up, he saw the car was left outside with the key in, so he took the car without paying for the repairs. He was liable for theft of his own car because the car was regarded as belonging to the service station for the purposes of theft because they were at that time in possession and control of the car. So if you entrust your property to someone else for a period of time, like for repairs or something like this, you can't just take it away without telling them because they are in possession and control of it at that time. In the case of Woodman, it was held that you can be guilty of stealing property even if the person in possession of it doesn't know it's there. So here our defendant had taken scrap metal from a disused factory. They didn't know there was still scrap metal there, but it was still a theft from them. So even if you've forgotten that you've got an item, that doesn't mean that it can't be stolen from you. And there are a couple of still on the issue of belonging to another, we've got Section 5.3 to consider in the Theft Act. Section 5.3 provides that where property in question is given to a person with instructions to use it in a certain way, the ownership of the property is deemed to remain with the giver until it's used for that purpose. And therefore, if a person receiving the property deals with it in a way which is inconsistent with the instructions, that can amount to theft. And this is quite a common situation. You might be guilty of this yourself. Say your mum's given you £1 to get the bus and you actually spend it on sweets. Technically, according to 5.3, that can be a theft because your mum gave it to you for the bus, not for sweets. This is illustrated by David and Benny. Here the defendant was given money by her flatmates to pay the gas bill, but instead she spent the money on Christmas presents. And she's saying that she shouldn't be guilty of theft here because the money didn't belong to another because they'd given her the money. But the court said, no, they've given you the money for the gas bill. So if you've used it for something else, that is theft. It still technically belongs to your flatmates until you've used it for that purpose. So 5.3 frequently comes up in scenarios, so do look out for it. Another situation on belonging to another is property obtained by mistake, and this is under section 5.4. And section 5.4 provides that where a person receives property by mistake, they're under an obligation to return the property, and a failure to do so will amount to theft. So in AG's reference, our defendant was mistakenly overpaid. And the Court of Appeal in this case said that if there wasn't an honest attempt to pay it back, then there will be a theft. This could equally apply if you're in a shop and you're given too much change and you notice but you don't say anything, then that can be a theft under section 5.4 because it's property received by mistake. Obviously, the difficulty there would be the shop proving that you noticed and you said nothing. We've looked at all the actus reus elements now. We've looked at appropriation and property and belonging to another. We now need to look at the mens rea. And there are two mens rea elements that we need to prove, and the first one is dishonesty. The Theft Act doesn't define dishonesty, but slightly strangely, it gives 3 situations in which a defendant's behaviour is not considered dishonest. And these are listed in section 2.1. Firstly, the defendant believes he has legal right. Secondly, he believes he would have the other's consent. And thirdly, the property is lost and he believes the owner cannot be discovered by taking reasonable steps. Section 2.2 tells us that it's still dishonest to take something and just leave money for it. So that's a practical rule to have. We wouldn't want people walking around the street going, oh, I like that cat, picking it up, taking it home, but leaving a tenner where you found it. That wouldn't work. So even if they leave payment, they can still be dishonest. If none of the dishonesty situations from section 2.1 applies, to determine whether the person's dishonest, we have to use the Gosh test, which has been amended by Ivy and Genting. And the test for dishonestly is now simply, would the reasonable man say it was dishonest? The last mens rea element is intention to permanently deprive under section 6. And the first case that we have on this is Velumil, where the defendant took some money out of his office safe to use over the weekend, and he was intending to put it back on Monday. So he was arguing it shouldn't be theft because he didn't have intention to permanently deprive. But here it said, because he would be paying back different banknotes, he did have intention to permanently deprive the particular banknotes he took. And we have this rule, which seems a bit daft, but the importance of this rule is so that you can't just be taking money and other things from your workplaces, and if you get caught saying, oh, I was going to replace it. So unless you're going to replace that exact thing, that exact note, it can still be theft. Sometimes somebody will borrow something and therefore argue, well, it's not a theft because they don't have intention to permanently deprive. I was going to give it back. In the case of Lloyd, they said that a borrowing can turn into a theft if you borrow property until the goodness, the virtue, and the value has gone out of the item. So if you were to borrow a top and slop red wine on it and it can't be cleaned, then although you've given it back, the goodness, the virtue, the value has gone, so it can be a theft. And the last case here is Eason, which says that we cannot have conditional intent for theft.